legally, who can be bugged?
Well, anybody can be bugged who the FBI or another federal law enforcement agency wants to bug. There's a 1968 statute that allows the FBI or other federal law enforcement agents to get a court order allowing wiretapping from the federal judge. What they have to do is show probable cause. It's just like a search warrant. They have to show probable cause that reason to believe a crime is being committed and a particular person is doing it, and they're likely to get information on the telephone for that. But in fact, since 1969, when the law went into effect, there's been about 10 applications for wiretap orders turned down. There's been thousands of orders granted by both federal and state judges all over the country. So in fact, both the federal government and state governments, where that's allowed, can tap just about anybody who they want to. The judges just let them do what they want.
Well, how do people know if their phone is tapped, and what can they do to get it stopped?
Well, that's the really insidious nature of wiretapping. You have no idea when your phone is being tapped. It's very unlike a physical search, which this is comparable to, where you know when somebody, a law enforcement agent, a policeman of some kind, comes into your house and takes certain things. You know exactly when he's there and what he's taking. He tells you if you're not there when he comes in. In wiretap, you just don't know when it's operating. In fact, when law enforcement people have wiretap orders, they operate the tap all the time. They listen to 100% of the calls coming in, 100% of the calls coming out. And you don't know it until long after the fact. People just talk and have the normal conversations, and they're all being overheard by the government. There's no way to know about it. The technology of tapping is beyond the technology of detection. There are a number of places where the technology can be applied in your home, but more likely it's done at a box down the street or 2 blocks away on a telephone pole. There's no way of detecting that using equipment in your own home.
So people are more or less helpless. They can't stop it if they don't know what's going on, right?
That's absolutely right. There's no way to stop it because you don't know what's going on. The telephone companies that we've had contact with have been very uncooperative in telling people about it. Very uncooperative in informing people. Yes, the government has just come to us to ask about a phone tap on your phone. There's just never any information coming out.
Well, somebody should be controlling this. You evidently think it is not being controlled properly. Who should control it? For example, say in a case of national security.
Well, the Supreme Court has held that national security is no different from other situations. The President, the United States government cannot wiretap people without a court order, just by saying national security is involved. They have to go to a court, have to go to a judge, have to get a judge to sign that it's proper to tap. Now, as I've said, the judges just issue orders almost whenever the government wants them to. I think what's very important is for the judges to take a much more active role in supervising this kind of thing, and for people in Congress to take a much more active role in overseeing things. Congress passed a law in 1968 and has made very minute changes in 1970, and those changes now help the government. There's no congressional oversight of the extent of wiretapping. In 1973, which is the last year we have figures for, there were about 800 wiretap orders issued, about 40,000 people overheard on telephone calls all around the country. That's what the government admits, and those are the numbers that the government offers. And those numbers do not include conversations in which there's a wired informer present. In other words, a law enforcement agent will have a tape recording device attached to it. Will have a microphone which will transmit to a tape recording device down the street or 2 blocks away. So there's at least that many conversations. A person is overheard at least that many orders. And Congress has just let that happen. I think it's very important for people in Congress to sit up and take a look at that.
Well, the long and the short of it is that you probably aren't, although, on the other hand, there are more cases of bugging going on than you think might otherwise be happening. We also wanted to talk a little bit about the statute, just to illustrate how, as often happens in society like ours, a statute can be passed by the Congress of the United States, setting up a whole set of procedures for the regulation and implementation of electronic surveillance, and yet after the statute's passed, basically forgotten about it. Judges pretend it doesn't exist, and so do police officers. And that whole statute, which was passed in 1968, has been virtually sabotaged down to its little toes. Later on, we'd also like, particularly for people who are active in the lawyers guild and in other political activities, we'd like to raise a question or a discussion by everybody here, not just by us, but because everybody would have some insight from time to time, and that has to do with what kind of priority we can place politically on struggles and work around democratic rights issues in the United States at this time, particularly in the face of At any rate, just to start out, it might be interesting to refer to a couple of things to set a few things that we got out of newspapers to put our discussion in some context. One is a print of a recent Lewis Harris poll, the results of which were printed in a San Francisco paper early in September. And I take it that's when the poll was conducted a few weeks before that. And the poll essentially indicates that approximately 80% of Americans are opposed to warrantless wiretap, and a slightly smaller percentage of them is opposed to wiretapping at all. There's really an overwhelming sense that the important interests of privacy at stake, and that people don't like other people, particularly government agents, snooping around, whether it's in their living rooms or their offices or their hotel rooms or wherever they may be. And people are particularly upset, according to this poll, when it is done without court orders, which has often been the case in the past. Later on, maybe people are interested in seeing some of the particular statistics that were referred to in that poll. We have it up here and people can check it out. Now, something else that we wanted to bring people's attention to is, remember, for many months we were all very occupied, preoccupied, and in some cases perhaps amused by the Watergate situation. And that lasted as a drama in this country for gosh knows how many months. And then, in a sense, Watergate is over, just as in a sense the war in China is over. No, neither is over. We tend to think they are, and we're moving on to other things. And one danger that is clearly rising is that Watergate will become very personalized. You know, it was Nixon, and it was Nixon's folly. It was Nixon and the cronies that he had around him, and that it didn't have anything to do with the nature of government power and its relationship to individual rights in the 20th century. And we would tend to forget that. However, we have people such as the FBI director, Clarence Kelly, who can still open their mouths and remind us that it wasn't just Nixon that was involved in Watergate, but there's a lot of other elements. And recently, Kelly, as if Watergate had never happened, made what was a series of statements calling for a reinstitution of authority to the Federal Bureau of Investigation to conduct warrantless wiretapping whenever they think that there's some threat to national security that's at issue. Now, I want to see if I can find some really good quotes here. He's talking about the need to find bombers. He says, we cannot now place caps on them. It is difficult to monitor their operations and be alerted when they attack. Our plea at this time is for legislation permitting wiretapping of these people. In the article explains the FBI supposedly has to have a warrant. Now, he concedes that it might be a threat to some civil liberties, but he says, quote, law enforcement has grown up. We can act with discrimination. We are responsible people, and we are not going to cause people to needlessly lose their rights. Now, the law and order mentality that had played such a prominent role in Nixon's rise to power and the ascendancy of the Republican Party in the late 60s, that whole mentality was being resurrected. Now, what we then see ourselves facing, in a sense, is a new wave, potentially, of repression, something that we feel we have to be prepared for. And this arises, again, remember, in the context of people looking at the Watergate situation as a very personal, unique phenomenon, and not something that grew out of the nature and the makings of our present system of government. Now, what this may mean, then, is that although we saw a certain freeze on repressive types of activities during the Watergate period, we didn't have really recently any great nationally known conspiracy trials. It seemed as if grand jury inquisitions, which had been rampaging for a few years, had ceased, and it seemed as if, well, it just seemed as if a lot of things had cooled off under the heat and pressure. What we find ourselves facing now is potentially a whole new context to these repressive activities. And the mentality that exists in the Kelly statement was something that was at the root of Watergate, and it might be good if Marty could stand up here a second. We have a 22-line skit that we do, and would you like to play Sam Irvin today, or should I?
I'll play Sam.
All right, I'm John Ehrlich. It's a very good pleasure to be here today, even though I'm on trial in Washington, D.C. This is Sam Irvin. Sam Irvin here. He's our expert on constitutional rights. And what we're reading from is from the Watergate hearing. Remember back in May 1973? Well, you're Sam Irvin. And what was going on here is Ehrlichman was being questioned by Irvin. And the subject matter of the question was the break-in to the Fielding office out in Los Angeles, Ellsberg psychiatrist.
Well, let us go on to something else now. You said something about the burglarizing of the office of the psychiatrist of Ellsberg was justified power under the Constitution, did you not?
Yes.
And you referred to a certain statute.
I referred to a statute in which the Congress in 1968 made a recognition of that inherent power.
Is that 18 U.S. Code 2511?
Yes.
Well, that statute has nothing to do with burglary.
It has to do with the United States Constitution, Mr. Chairman.
No, sir. That is not the purpose of the statute. The Constitution takes care of itself, even there. This has to do with the interception or disclosure of wire or oral communications prohibited.
No, sir. It also has to do with Congress's recognition of what the Constitution provides with relation to the powers of the President.
Well, is there a single thing in there that says that the President can authorize burglary?
Well, let us read it, Mr. Chairman.
Well, I can ask about it without reading. It says here that this statute, which makes it unlawful to intercept and disclose wire or other communications, says that this shall not interfere with the constitutional power of the President
to do anything. And that's the long and the short of it. And that's the position that they took, and that's the position that Kelly is still taking, ironically enough, after all those months of Watergate. And when they say that they can have discrimination in their power to do anything they want, what we need to do is examine the record of the warrantless national security wiretapping that took place over a 3-year period between 1969 and the early part of 1972. Wiretaps without warrants. And well, that doctrine, from that point on, was challenged by people on trial all over the country because it was invoked in cases all over the country when the government refused to disclose wiretapping that they had conducted. And eventually that doctrine went up to the Supreme Court where it lost 8-0. And the reverberations of that loss have been sounding ever since, including in Ehrlichman's own trial when he attempted to raise this defense and the court said, we can't even get that defense in this court. Raise it here, it's so far out. But anyway, the wiretaps that went on with the discrimination that was supposedly involved were about 60 in 1969 because they were only using it half a year, and there were over 100 of them in 1970, and another 113 in 1971. And these were not wiretaps that were taking place necessarily just for 5 days here or 10 days there, trying to get after a gambler or some drug addict or something like that. These were wiretaps, for example, that were placed on the SDS National Office in Chicago in 1969-1970 for a solid 12-month period without stopping. They just turned it on and never turned it off. There's one major civil suit that's now pending against the government for the illegal activities involved in these wiretaps. And that civil suit is in a certain where the people who are the plaintiffs are now allowed to get some of those government records. And the amount of records that they're entitled to get now add up to over 100,000 pages of material, of transcripts.
To the brother sitting here that this is maybe a unique case in that people may start off as legal workers, go to law school, take the bar and get admitted and still be ready for an Attica trial by the time this is completed. This is going to go on for 5 years, the Attica trials. They have allocated 4 courtrooms, period, for the Attica trials, and they really can't afford that.
We now return to National Lawyers Guild Convention. Don Jelnick, who is the leader of the defense for the Attica brothers, is speaking.
Eventually, or I'll put it a different way, the state has, the indictments that have come down, 1,300 counts, is the greatest overkill that I've ever experienced, that I've ever heard of. Even the indictments themselves are done very strangely. As Linda noticed the other day, they will have the variations of the same crime in the indictment. In other words, ordinarily you would say assault 1, but they have assault 1, assault 2, another variation on assault 2. They'll write it 5 different ways where they could have just had one charge of assault and the judge would have broken it down. The purpose of those indictments, in the same way the purpose of these rump hearings that we just finished, are to terrorize the brothers. The only way, they cannot handle 75 trials much better than we can. They are counting on 75 trials to get 2/3 to break and indict the other third and convict the other third. They don't want all these people. They have people charged with contraband. They have people charged with possession of a gas gun. They have people charged with sodomy, which is probably related to the fact that of the homosexual activity that usually went on in Attica, probably 2% of it was still going on in the yard, as went on upstairs generally. They have taken every conceivable crime they could get their hands on, except felony murder. Isn't that interesting? Why not felony murder? Why charge everybody with kidnapping and not with felony murder? Because felony murder means the massacre would have to come into evidence. Right? They'd have to explain the death. So they left out the felony murder charges and just left it as kidnapping. They have geared the entire thing for a political showcase, in my opinion, to help justify Rockefeller's re-election, so he doesn't run into the Pat Brown syndrome, who lost over the Carol Chessman execution. But whether or not that's the specific case, I think what's really important is that they want to break the brothers. Do you know that when we went to court, the date to get motions in was to be July 2nd. That would have given us 20 days from the time we finally learned where the venue was going to be. And of course, how could you have lawyers until you know where the trial is going to be held? I asked for an extension of time for 60 days. The 5 private lawyers came up and said openly, Judge, my name is so-and-so, I have 1 client charged with 3 charges, I have 35 clients charged with about 800 charges. I have 1 client with 3 charges, and I'm only in the case a week, and I'd like a 2-week extension granted. Attorney General never even spoke, just made his notes. We had an hour-and-a-half argument. For an hour-and-a-half, the judge took debate on our request for an extension of time, and only at the last moment decided to grant us 14 days for the extension. And in my rebuttal to the argument, I said it's time to put legal arguments aside and be a little more realistic. Though I didn't say it, it reminded me of a wonderful lawyer in Mississippi by the name of Jess Brown, who was arguing a case involving a pool in Mississippi, in Jackson, Mississippi. And the pool had been ordered integrated, and then the city fathers closed down the pool. And they closed it down because of the excess of chlorine. That was the reason. And this case in the Court of Appeals, the U.S. Court of Appeals, 5th Circuit, or rather in the District Court, and they have this chlorine expert. He's on the stand, and this is going on for 3 hours, this chlorine discussion of why this pool had to be shut down. And finally, Jess Brown, who didn't go to Harvard or Yale, he stood up and said, Judge, we don't know it's just because they don't want colored people in that pool. But he got right to it, and I felt that somehow that the same argument was needed here. And I pointed out, I said, who are you kidding? There's only one reason why this fight is going on, and it's because the Attorney General and this court do not want radical lawyers in these cases. By not giving us enough time, on July 2nd, they were going to have court-appointed lawyers, motion date and court-appointed lawyers. We know that the reason what you want the Buffalo Bar to come into this case and deal it out. cop it out. On a daily basis, as I go into the jail or prison, a brother will tell me that he's heard through the grapevine, which usually comes from some pig, that some other brother has signed an affidavit against him, is testifying against him. And I asked the brother, what has he heard? What are the details of it? What names? Who did you speak to? And I track it down from person to person. That takes almost a quarter of my time until we find out that it's a rumor that's been planted by the pigs. Because that's what they want. And with court-appointed counsel, they'll succeed in it. The only way they are going to put the Attica brothers in prison for the rest of their lives, and by the way, it's not the Attica brothers they're concerned about, but it's the end of prison rebellions. Because if the Attica brothers do not get support, if the Attica brothers are left to hang, and if the Attica brothers spend the rest of their lives in prison, the word will go out to other prisons all throughout the United States. And this is sort of the test ground of this all. So what we are doing, or why we are here, we are going to come back, and we only have till a week from Monday. What's today? Saturday. We only have till a week from next Monday to have a court-appointed brothers who are unrepresented. But that doesn't mean 35 lawyers, because they're in different indictments. One brother is in indictment number 5, which has 640 counts and 18 co-defendants. He can't be tried at the same time with his indictment number 15, which has 10 brothers and 400 counts. Even 35 brothers need 60, 70 lawyers. And if they're not in the case, if they're not on record, by a week from Monday, the court-appointed lawyers come in, and as one of our brothers in Detroit, Neil Bush, said, he has somebody in Detroit, he could wrap up all these trials in 15 minutes. He could deal them all out, probably do it in 10 minutes if he had to. They got power against citizens of this nation since the shots heard at Lexington, and like the sound of that crack of the fusillade in those days, it was hoped by many people that the facts developed would breathe finally some life into the nostrils of the movement for effective and meaningful prison reform, which for so many centuries regrettably was consigned to dusty tomes written by well-meaning bureaucratic powerless reformists. And he goes on to say, nevertheless, this is a case and not a cause. And his job is to represent his client, and he had told me privately that if necessary, if that meant testifying against other brothers, that's his duty as a lawyer to get him off. His name is Berzon, and we want sort of an anti-Berzon loyalty oath for anybody who comes into Attica cases. We want lawyers who believe in the brothers, not in the hypocrisies of the canons of ethics. We want lawyers who believe that the Attica brothers are not individuals, though they are wonderful people, and Linda is going to talk to you about them as people. But they are also the Attica brother, whether they're charged with contraband or murder. They're being charged because they took part in the rebellion. And anyone that's convicted will not be convicted of contraband. He will be Attica brother convicted. And the jury will see him as an Attica brother. And the DAs are assembled to get the Attica brothers. And if I thought there were a way of defending them by taking this parochial approach, if that were the way that all of them could go free, no problem. But they're not going to go free except as a group, like our Soledad 7, Soledad 3 in California. Only with a political defense, only with people who will not allow them to be played one against the other. It's for these reasons that we desperately need the help. Now, I want to stop for a moment, because by the very fact of my having talked about them as a unit and as a team, and it's important to think of them that way, I want you to know them as the wonderful people they are. And Linda, who's project director of the work that goes on around the brothers individually, can tell you more about that. Linda?
I think a little background. When we came into Attica, the location of where the brothers were at that time was Auburn Prison, which is about 300 miles from New York City. And almost all of the Attica brothers are from New York City, which means when we came up, some of them hadn't had visits from lawyers or family for 2-3 months. They're all in segregation. They all get 1 hour per day outside their cells. And so there had been literally no contact. They hadn't had any contact with people for the longest of time. Coming up to work on the Attica program, we wanted to reestablish a human link so that the brothers could reestablish their ties to the community and could be able to see and meet people. And we started what is now known as the Attica Summer, and have approximately 30 lawyers, law students, and undergraduates working with the Attica brothers now, and they're all linked up one-to-one with an individual brother so that they can help the brother with his bail problems, help him with his parole problems, help him just make telephone calls and say, you know, happy birthday, mother. And it's been really rewarding. The program has just been going for 2 weeks, and so much has come out just in the last 2 weeks. One of the brothers, while we were in court, said, can you make a medical application? I have a piece of shrapnel in my skull from the rebellion. Nobody's taken care of it. I've been in prison since the rebellion. Nobody's bothered even taking an x-ray to see if they can remove it. One of the summer people is working on filing an Article 78 so that he can just get an x-ray to get that piece of shrapnel out of his skull. Another one of the brothers, by the name of Roger Champion, came up to us after court and he said, you know, come on, I want to sit down and talk with you. And we talked for a few minutes and he said, you know, I just got out of the joint after being in the joint for 15 years. When I went in, I had a 2-year-old son, and now my son is 17. And I'm just beginning to know him as a person. I haven't seen him for 15 years. I can't leave his side. He's with me all the time now. We travel together. My wife, she waited 15 years. We traveled together, and he's been going, I think people who were in Chicago saw him at the NEB there. He's been traveling with his family. It's the impact of knowing that a man's been separated from his family for 15 years. And that if he's convicted for the Attica charges, will be back in the joint for the rest of his life. It's overwhelming. Another one of the brothers, by the name of Chuck Pernasseles, just had his 21st birthday. Chuck is on indictment number 1, which is the murder of the guard in Times Square at the beginning of the Attica Rebellion. He's charged with that murder. He was 19 when he was charged for that murder. He wasn't even supposed to be in Attica because a minor is not supposed to be in Attica because it's a maximum security prison. Somehow the bureaucracy of New York State prison systems got a 19-year-old into Attica. He was picked up. They came down with the sealed indictments. He was picked up in his mother's home on a Saturday night. He's at home playing the guitar. They come in, they arrest him. No indictments, they're sealed. He doesn't know why he's arrested. They forget to bring the handcuffs to arrest him. They tie him with the leather cord to his guitar, take him away. He's still in. The judge has refused bail, and there's been 2 bail hearings, and we're working on taking it up on a writ now. Getting to know the brothers is just really, there are about 32 brothers who are in now, and the range of personalities and who they are as people is just amazing. There are a lot of problems, as there are with any people who are in the joint. There's several who have had severe psychiatric problems since the rebellion. There's one who during the rebellion had a psychotic breakdown under all the pressure, and he's been in and out of psychiatric facilities since then. There's another man who, on the day that the sealed indictments came down, was in Mattawan, which is the state psychiatric hospital, and they brought him from Mattawan at 5 o'clock in the morning. This is a man who's suicidal. They brought him from Mattawan to Warsaw, which is maybe a 400-mile trip, at 5 o'clock in the morning. Didn't tell him what it was about. Got him in front of the court, charged him with umpteen things, and then brought him back to a cell in Erie County without any medication, nothing. No fact that he had just been taken from a psychiatric facility. That night he attempted to hang himself. Returned to Mattawan, same thing happened to Mr. Raymond. here. They took him out of his cell at 5 o'clock in the morning to bring him back for these arraignments, of which we're not really, which Don has explained to you what it's about. His lawyer appeared in court and said, you're fucking with this man's life. You did this before to him 6 months ago, and he attempted suicide. And is an impassioned plea, and the judge finally said, okay, he doesn't have to be brought into court. But the man had already been dragged 400 miles across the state. I don't know. They're just, I think I could probably go on for about 6 hours describing the individual brothers.